of Saskatchewan, I'm so pleased to welcome you to the first guest lecture of the 2014-15 academic year, the Cronkite Lecture. This lecture is part of the newly named McKercher LLP Lecture Series at the College of Law. McKercher LLP has generously agreed to sponsor our lecture series for the next 3 years, allowing us to continue to present a wide range of informative, educational, and entertaining speakers to the law school community. And I'm very pleased to say that David Stack, partner with McKercher, is here. And I just want to, perhaps we could just thank David and pass along and ask him to pass along those thanks to his partners and the associates at McKercher LLP. With offices in Saskatoon and Regina, McKercher is one of the largest law firms in the province of Saskatchewan and has been honored by its clients and peers by being ranked one of the top law firms in Saskatchewan by Canadian Lawyer magazine in February 2013. The firm provides a wide range of legal services and serves local, national, and international clients, including the University of Saskatchewan. The Cronkite Lecture was inaugurated in November 1978 and was given by the Honorable Mr. Justice Emmett Hall. It was created as a memorial to honor F.C. Cronkite, QC, Dean of the College of Law from 1929 to 1961. I'm sure that Lorne would join me in expressing some astonishment at the longevity of Dean Cronkite. Dean Cronkite is the longest-serving dean in our law school's history. And the lecture that honors his name has traditionally presented subject matter related to public law. This year, we are proud to welcome Lorne Sossin, Dean of Osgoode Hall Law School, to deliver the Cronkite Lecture. Prior to 2010, when he became Dean, Lorne was a professor of the Faculty of Law at the University of Toronto. During his time at the University of Toronto, he also held the positions of Associate Dean and Director of the Centre for the Legal Profession. Prior to that, he was a faculty member at Osgoode Hall Law School and the Department of Political Science at York University. And prior to that, we were classmates.
Absolutely.
His teaching interests span administrative and constitutional law, the regulation of professions, civil litigation, public policy, and the judicial process. Dean Sossin was a law clerk to former Chief Justice Antonio Lemaire of the Supreme Court of Canada, a former associate in law at Columbia Law School, and a former litigation lawyer with the firm of Gordon and Elliott. His areas of research interest are human rights law, legal process, legal profession, poverty law, and public law. Dean Sossin also serves on the boards of the National Judicial Institute, the Law Commission of Ontario, and is a vice chair of the Ontario Health Professions Appeal and Review Board, as well as being a member of the Health Services Appeal and Review Board. Lorne served as Interim Integrity Commissioner for the City of Toronto in 2008 and 2009, and is currently the Open Meeting Investigator for the City of Toronto. Without further ado, Dr. Lorne Sossin.
Thanks very much. Thanks very much to the Dean. Thanks very much to McKercher LLP and to the University of Saskatchewan, and the incredible warmth I've been experiencing in Saskatoon is matched only this time by the lack of contrast to what's going on outside. Last time I was here for the centenary, which was a wonderful event, was accompanied by, I think, the first bizarre blizzard of the season. I spent a night at the Regina Inn at about 3 in the morning because we were in a holding pattern, and they decided to try again the next day. Made it here for the conference, but it was a much more memorable journey than this time, where the sun, the beautiful fall weather, the chance to talk to people and get to see a city that's going through such transformation has been wonderful. And I also want to acknowledge the importance of being in a province that has such a connection to accessible public services, such a rich history of that, and to being on Treaty 6 territories, and to all of the connections that I hope will become clear between a subject that many people don't immediately think of when public law comes to mind, but I very much view through that lens. And I think there's a neat connection, and Beth Bilson was telling me a bit more about it than I had gleaned from the information on Dean Cronkite that I was aware of just how connected he was to legal education and to connecting it up with other important public and professional values. So I hope this does justice to some of what made him tick for so many years, and that is an astonishing longevity for any dean. So my approach, I think, is a simple one, and I hope a compelling one, but not an uncontroversial one. And that is that while we would all wish there to be more that government could do or more that other funders could do to achieve accessibility, there is much more that we can and should do as institutions, as universities, as law schools, than we're doing, and that failing to do so is not simply incidental to our mandate or mission, but fundamental to it. So the idea of how much we're focused on change and flux in the delivery of legal services, in the nature of the profession, in the content of our curriculum, in all the substantive aspects of legal education, can't be disentangled, I would suggest, from the importance of accessibility in all of its contexts, so that if we're defined by the people we attract, the people that make up our communities, and the people that go on from this education or this community to make change, solve problems, blaze their own trails, the idea that we're missing out on some of the most transformative of those people because our institutions aren't as accessible as they ought to be is a public concern. It was when we erected barriers that kept specific ethnic groups or religious or linguistic communities or indigenous peoples from accessing our universities and education, and that is one of those aspects of accessibility. I think there's a much better news story to tell about, but it's juxtaposed to aspects of financial accessibility where I think the story has never been bleaker. At least I'll share with you some of the Ontario reflections on that and look forward to discussion about what's happening here and where it's going. So the first context that I wanted to share with you about how I see the accessibility concern is what the public is seeing on the outside. And the public on the outside of our institutions, I think it's fair to say, is seeing a dire portrait of legal education. Part of that is driven by much of this originating in the U.S., the view that there are no more jobs for lawyers, that legal education has tuition in the U.S. that has become predatory. It's given rise to class actions as people feel they've been given a bait and switch on the career prospects that would include, people hired by the school, people working in Home Depot as having careers related to law after graduation. So even though the class actions haven't succeeded, the reputation has taken a huge hit, and the applications in the U.S. are substantially down. And even though, as with many of the consequences of 2008 and 9 in the recession, it's milder in Canada, we've noticed, for example, this year a 10% drop system-wide in applications to Canadian law schools. That's not the same kind of denominator as what's going on in the U.S., but it's not nothing either. So one context I wanted to share with you is this sense to which, because the market for legal services are changing, because law schools have been seen as overpriced and not providing access to the kinds of value that students are looking for, that the case against law school has been growing. And at the same time, and again, this is a more Ontario phenomenon, but I think those provinces that are too complacent are experiencing that at their own peril, is the articling crisis, this notion of far more people seeking articles than there are positions, and that number in Ontario is now in the several hundreds and expected to continue to grow as the market remains flat and more new law schools start and more law schools offshore in Australia and the UK attract Canadians who want to come back, and we become more globalized. So graduates from all sorts of countries around the world are seeking to find their career paths in Canada. So all of these together have conspired, I think, to bring accessibility to the forefront and also to give that sense of urgency, that sense that whether or not it represents our values, we're seen more and more as a place remote from how the public views the public good. And I think that is, of course, ultimately the benchmark by which we are measured and ought to be measured. So I'm going to just touch on the first two dimensions of accessibility, and these aren't the only three one could come up with, but they're the three that I find the most compelling and certainly the most top of mind as we are looking at different innovations and initiatives across the country under the banner of accessibility. I'll touch on the first two and then spend the balance of my time on the financial accessibility, the third point. But the first point, diversity and inclusion, I think is worth commenting on because it may be a false positive. This, by the way, is one of the pictures we're playing around with for our 125th anniversary greeting card for the holidays. We're trying to blend that sense of old and new. I think this lacks a bit of the subtlety that one might look for in the blending of old and new, and my kids thought it looked, frankly, a little creepy, but we are going to have some variation on what an Osgoode class used to look like, what it looks like now. And we've been publishing our demographic data through a universal survey. Universal, of course, is law school code for mandatory. And it's mandatory because you don't get your first LRW assignment unless you pass through the survey, kind of like the gift store after the wax museum. If you ever want to leave, you go through it. Now, of course, no one has to fill out every question, but we get pretty close to 100% take-up. And found, for example, that slightly over 40% of our incoming class last year identified as something other than white, right? And that is a bigger number than we've ever had before. It might be a bigger number than most other schools in the country. But when you start to look at the other factors, we found, interestingly, that socioeconomic access looked pretty much identical to what it looked like 3, 4, 5, 6, 10, 12, 15 years ago, even though we didn't have quite as good data. So it's all with a caveat in terms of the numbers. And what's that saying? I mean, one of the things it's saying is, of course, that more diverse communities are becoming more affluent. And so if your real barrier is socioeconomic, it shouldn't be surprising that with higher tuition, we are looking more like Canada, more like Toronto or Ontario in our case, more like Saskatchewan here. And that is both a success story because, as I said, it wasn't that long ago that schools just expressly either said, if you're part of this community, you can't come, or found proxies. And the latest was the search for community service in medical school, which was seen as a way of focusing less just on grades, which had a disproportionate effect on certain ethnic communities over others. So this debate is very much one still going on, and I don't want to suggest there are no more express barriers of that kind. But I think most schools I'm aware of, in fact, celebrate inclusion and are proactively seeking to bring in diverse kinds of students, at least from the pool already applying to law school. And we have varying levels of success, but I think we're well on our way if you simply measure the diversity and inclusion story by those kinds of community affiliations or identity. And in fact, the fastest growing category in our survey will not surprise you, and it's other, right? It's people who have two parents from different ethnic or racial communities and simply don't like the idea of being compartmentalized at all. The very premise of a survey they find vaguely offensive, that you would try to box them in that category. So we're going to have to rethink diversity and inclusion, I think, to find a way to articulate it that isn't about these particular groups that are categories on a census or on a survey. The second area, and I said I'm not doing these justice, I just want to provoke a little bit of thought on accessibility in these contexts before, again, focusing on the financial, because I think accessibility is a term used in all of these areas and probably should be. So having some clarity on the breadth of it is important, I think, before exploring a bit of the depth. And the second concept that if you mentioned accessibility outside the law school and university inside the Beltway community would probably mean to them, you mean like a ramp. You mean like accessible for people living with disabilities or people who have difficulties getting access to materials. And it is that. So accessibility in the second dimension has really been expressed as accommodation. And here the challenge is, again, moving from a discourse that is all about how can we build that ramp, or how can we, if you can't write an exam in a 3-hour sit-down context, we've got another classroom where you can write for 4 hours, or we'll find some way to accommodate your difference. And I think here, again, the next move, if I mentioned in diversity and inclusion, the next move is getting beyond the survey categories. Here, the next move is getting beyond a discourse of accommodation, which premises the idea that there's a norm. The norm is good and right. But if you're different from the norm, we'll do everything we can to make sure you're in the same position as the normal people, right? And so that is going to give way, I think, and I hope, to a culture of joint ownership, of universal access in the project of a law school or a university. So instead of saying there's a 3-hour sit-down exam, and if you need extra time, we'll put you in another room, it's saying, why do we need to have people sitting in a room for 3 hours? What is that really assessing? What if we said over these 2 weeks, you'll take out these exams, you'll do them in whatever time frame might be set out, you'll get them back, they'll be assessed, and you don't need to disclose, never mind have accommodations, that you may have 3 jobs and need to work in the wee hours, and you may have an anxiety disorder and need to work with a particular kind of lighting or music. And, we only create the need for the accommodation by approaching the norm as good and right. If we take a universal design approach, there's a whole swath of law school that may look different. And again, I just have up on the screen one step, I think, in the right direction, which is an Ontario-wide initiative for law students funded by the government. So sometimes government can still be a necessary partner, even if not the source of all the solutions. And this has a series of tools, resources, peer mentorship, organized by schools or by the kind of challenge you're having. So if you go under my concern, and this is just a screen capture, so I can't take you through all of it, but it's organized by what you're feeling. Are you overwhelmed? Are you stressed about work? Is it a relationship breakdown? Are you feeling lonely? Do you have a sense of hopelessness and despair that might be masking an undiagnosed mental health issue? All of that is something that this is aimed at addressing, not with the idea that this will position you as other than the normal law student, but with the idea that this is the normal law student. And we had this interesting dilemma at Osgoode. We brought on a student success and wellness coordinator, counselor, and the issue we faced was, where does she live? Right? If she's behind the double glass doors to student services, the worry was some people won't go through those doors and wait in line for that service. And if she's in an unmarked office on the 4th floor behind some shelves, then what are we saying about the students who need those services? She had an easy answer. She's smarter than most of us, and of course has the expertise to bridge these communities, and said I can be behind the double doors for the students who want to find me there, and I can have a confidential email portal and go meet students wherever they're more comfortable and be, in that sense, not linked to any location, because it's meant to be responsive to each student's individual dynamics. So that notion of accommodation as accessibility, I think, will give way to the idea that there is no norm, that everyone's experience ought to be seen as the norm, at least through the lens of that student. And of course, all of us, I think, are not there yet. So that brings me to the third and really the focus of what I wanted to share with you, in this sense that there is far more that we can do without relying on the big systemic change that we know would be needed to move the dial on actual tuition rates or growth of tuition, that the certain realities that all of us are experiencing is not so much that universities are getting wealthier because tuition's going up, but rather the share of cost of educating someone, particularly in a professional or legal context, is being shifted from government to the students themselves. And we crossed a threshold now about 5 or 6 years ago in Ontario at most of our law schools when the ratio of government support slipped below 50%. So the government is now a minority shareholder in the enterprise of giving a student a legal education. And that, of course, is going further and further down every year. The share paid for by the students going up every year. And, of course, the amount given out in financial aid is going up as a proportion of that. We at Osgoode now give about $3.5 million every year in financial assistance in bursaries, scholarships, and the like. Our tuition is $23,000 a year. And this is a reality that now interposes third-party lenders, primarily banks, although government loans are significant too, as a major way stop on the way to your legal education. That has, of course, implications for the other two senses of accessibility as well. It can be the catalyst for stress and anxiety disorders. It can keep swaths of the community who are particularly sensitive to sticker shock from even considering legal education, never mind from taking the plunge at a place like Osgoode. So, this notion of high tuition, of high debt, and of, again, staggering financial walls to surmount is relatively recent and is growing at a fast pace, although in different ways in different parts of the country. Quebec, obviously, is a different narrative altogether, and here in Saskatchewan, the growth has been very significant within a context of a starting place that was much lower. So, it looks like Osgoode or U of T, which is the most expensive law school in the country, now at $30,000, is in another league. But I can tell you when U of T's tuition hit $12,000, we said that was a national crisis and all ran to various barricades to do something about it. So this is something, again, that over time you just have this entirely different price sensitivity to, and the numbers that shock you may not shock the kids who are now in grade 9 who will be the law students of the future. But it has, of course, led to important protests. There was a protest that really gathered steam last year at the University of Toronto around this $30,000 mark and led to, I think, the wearing of yellow buttons at convocation. It led to picketing Welcome Day when the parents all come with their kids to check out law schools. They were leafleting, and there was a sense to which this was a proxy for feeling not only taken advantage of by the system, but really being an object of legal education rather than the subject of it. And one sees this replicated throughout the province. And again, I worry sometimes if I'm coming to talk to you about Ontario, it's going to be a trailer of what's coming soon. But this, of course, is not the only path a school or a province need take. But in Ontario, the students got together from all the Ontario schools, there's 7 of them now, and conducted a survey of debt and the law student experience, memorably entitled Just or Bust, which I think no doubt will catch on. You may not be able to read the fine print of this is from the summary of high-level takeaway points. But just to share with you the one or two pieces of data that struck me as particularly important. One is that there still are about 30% of students who graduate at these high tuition schools with no debt, just relying on family support. And obviously it's not simply that they're going to have a very different stress-free kind of experience in law school, but law school is actually going to cost them a lot less. So the implication of high borrowing is not just the wall you need to surmount, but also at the end of the day, the cost of that education is going to be significantly higher than if you bought it all up front without having to go into debt or pay interest. So that inequality is something that to a public institution, just on its face, seems relatively unjust, or at least hard to find an account for why we would see that education having that kind of differential value, depending on the money you come with. The amount of debt owed by those who owe debt, so this is always a bit of a skewed number, because if you factored in the 30% with no debt, these numbers obviously come way down. But looking at those other students who had debt, by the third year, the average in Ontario is over $70,000. So this, again, highlights the drama. We don't have easy ways of knowing people's income coming in, so we tend to use proxies for socioeconomic access, like the percentage of students with parents who have at least one university credential, which has always been a proxy for being middle class or more affluent. That's now over 80% on average, and 60% said both parents have that. So this, again, is underscoring the sense of exclusion or that lack of accessibility that we are seeing. And the numbers, I won't belabor them all from the survey, but it is stark reading, and the more you penetrate the survey, which got remarkably high take-up, I think because it was generated by students for students, the more there's a picture emerging of a reality that's simply unsustainable, or at least unsustainable if we still want to tell a great story about our law schools. And I think but for accessibility, we have great stories to tell. I think the experiential turn at many schools, the engagement with solving problems, the integration of digital legal education, the amazing interdisciplinarity we see afoot, notwithstanding new regulation of curricula and all sorts of other barbarians at the gate, as it were. It's a remarkable time to be at a law school. Far more interesting, far more energizing, far more relevant than the scant 25 years ago when I was a first-year student at Osgoode. But that story gets drowned out if most of the people who might actually transform the profession, do amazing things with that education, are up against the window of that law school, pressed and looking in, but not able to get through the door. So this has led to hand-wringing, to calls for action, much like the access to justice debate, more calls than doing, and more study than action. But the CBA, in their futures report, focused in particular on this notion of forgivable loans. And I think there are kind of three strategies to financial accessibility that I wanted to share with you. One is this notion of structuring how we do financial aid to actually get at the root problem. Second is changing the timing of how one goes to law school, a flex time LLB or JD rather than our typical full-time study model. And third, I'll have something brief to say about funded internships and other ways to combine accessibility with other enrichments in law school. So this is not a very good picture, but it is, I think, a pretty interesting idea, and one that, as we looked at the notion of debt and said, what would actually not just address what we're hearing from students in the program as stress-producing, career-limiting when they graduate and feel unable to pursue what brought them to law school because of their debt load, but also what would actually bring people in the pool who now are shut out or shutting themselves out of legal education entirely. And the notion we settled upon after lots of talk with students and faculty and staff in the financial services area and others was income contingent loans. Now, income contingent loans are a remarkably simple idea. It's study now, pay later. So you pay nothing up front for law school, and at a time when you've graduated, are employed, and already have an income that allows you to afford the incremental payment of tuition, that's when you start paying it. So one could either pick a figure. Some figures at schools that are exploring forgivable loans generally has been in the $50,000 range, let's say. So as your income hits $50,000, you start paying it back. Until it does, you don't. And if it never reaches $50,000, the loan's forgiven in its entirety. So this kind of model takes away both the sticker shock and the sense at the end that you've got to go in a particular career path. It also reflects the public interest nature of law school, the idea that you're investing where the collective good is served by the work done by a graduate, and looking for greater contribution when that good is more expressed in private benefits, even though those are rough, bright lines to pick any income level. Some have suggested, by the way, instead of an income level, we should cluster 3 first-year associate salaries, say Department of Justice, a large Vancouver firm, a large Ottawa firm, or a Toronto firm, or a clinic, and say, combine all those together, and that average, whatever it is 5 years from now or 7 years from now, that will be the amount, because it kind of indexes for the actual market conditions we're looking at most students entering when they graduate. So this idea, just to give you a sense of why everyone's not doing it, it's not for the faint of heart. We had to find some one-time only startup money, because the big challenge with this is once it's rolling, you're getting significant payback, you're forgiving some loans, it's sustainable, it's manageable, and I think it's socially just. But to get there, you've got to cover all the costs for like years before you're going to see anything back. So we've got a pilot of 5 years, which takes us, we hope, to the first point at which we're starting to see returns. And to get there for 5 students a year, over 5 years at least, again, we hope to grow it further and for longer as we get more funding on board. But to start with, we set aside $1 million is what it takes at Osgoode to get you from 5 students a year for 5 years in this program. So again, it's got a great upside, I think, and I think the thinking behind it really represents what schools can do. When U of T started its back-end debt program, it simply shifted money from the front end to the back end. It said there's going to be fewer bursaries to come and more back-end debt relief when you go. And Manitoba's loan forgiveness program that was celebrated in the CBA report focuses on what you do afterwards, particularly going to underserviced parts of the province. I understand the take-up, bless you, may not be huge on that, so the proof is always in the pudding, right? Who's really getting the benefit? And the Law Foundation of Ontario tried something called DRAP, the Debt Relief Assistance Program. 1 student from each of the 6 schools doing public interest work after law school would receive approximately $6,000 each year that they're seeking or in that career path. But it turned out to be ridiculously hard to administer for a ridiculously small number of people, even though it was ridiculously generous and expensive when you added up how much that cost the foundation. So you've got to get the balance right between affecting lots of students and I think having a great ability to sustain itself. But it's not the only idea. The one I'm hoping we'll be in a position to announce this time next year, and the second of the 3 strategies I think we could do tomorrow within our resource base, and I say we, all law schools, not Osgoode, is somewhat unglamorously called part-time law school, or a flex-time JD program, but the premise is equally simple. It's the idea that shouldn't you be able to obtain a law degree without giving up your full-time employment or family responsibilities if you're not in a position to do so. And there's a range of people for whom no amount of financial assistance can address that inability to marry legal education with the complications of their life. So the thought experiment is, what if we taught law school when students were free to learn it rather than when it's convenient for us to provide it? And that's a fairly radical notion for those of us in university administration and course design and all the moving parts of a law school. But again, the upside can be potentially revolutionary, and the stigma can be potentially devastating. The night school idea in many U.S. cities can often connote a lack of quality or less rigorous intellectual standards, even though if you look at the U.S. News and World Report rankings, always a boulder of salt on our minds as we do so. Georgetown, one of the best law schools in the U.S. and one of the oldest to have a part-time program, aimed initially at the federal public service in Washington, has a program that flourishes. So I think this notion that you can combine accessibility with also innovative pedagogy shouldn't be lost on us. What would it look like if we tailored a JD for the flex-time student who's going to do this over 4 or 5 years? How would experiential learning and lawyering competitions and LRW and summer work and clinics, how would it all work so as to give those students the best parts of the community and the experience with the best parts of accessibility? And in this case, it can be combined with financial aid or simply itself be a form of financial aid, that you can keep your full-time income stream and pay tuition in that way. So I think the notion of a flex time or part-time program also comes together with what's affectionately known by those promoting their book as Law School 2.0, the rise of digital legal education. Does this have some lessons in how to connect some of those communities of part-time or flex-time students in the same way that we've learned through our professional development wing that services mostly legal professionals involved in lifelong learning, that you can have amazing intensive courses over several weekends or on the evenings once a month or more intensely that all generate different kinds of learning. You digest ideas differently, you connect with each other differently. All of those are opportunities, even if the gadgetry and the new and the shiny may not always hold the promise of all the answers. So that brings me to the third and last of the innovations for financial accessibility I want to share with you. This slide, of course, is going to be well known to many of you. It's one of the many collaborative and interesting new funded summer internships that have been sprouting all across the country. This one involves law and other faculties at University of Saskatchewan and the NDP program. There's one that caught my eye at UBC in environmental justice that in particular builds on public and private organizations involved in environmental law, puts students in external placements there, but funds it from a donation to create a public interest program. And at Osgoode we have something similar in the health law field that also honors two activists from the tainted blood scandals of the 80s and 90s who came out of Osgoode and fought for patients' rights. Both passed away of complications from that tainted blood, and a further person who had lived through that experience with them. And always convenient when you have someone who is living through that experience who goes into investment banking. And this person said, you know, my worry is who are going to be the next you know, Krepner and Platers of the future, the two individuals who had passed away. And this was a way of not only creating that enrichment I mentioned, but these are all needs-based internships, or at least the ones I'm most familiar with, so that accessibility comes together with great skills, great enrichment, and great community building, not to mention serving important communities of justice. So those are three things I think we could all be doing more of tomorrow. It doesn't mean we don't need to lower tuition or deal with debt in other ways, but it means the idea that we need to wait on all that happening or simply wring our hands and lament the fact that it's not happening is not an appropriate response, at least not for law schools committed to the notion, as I think Dean Cronkite was, that a legal education serves the public interest, that we ought to have it located in public institutions, and even if we can no longer manage to fund them as we might wish, because we're making choices about scarce taxpayer dollars, that doesn't mean we can't together ensure they live up to the requirements of a public institution and are seen to be doing that from the outside. So accessibility in all those three areas, but particularly these days in the financial aspect, I think is ripe for innovation. I think students are justifiably demanding it, and I think the schools that rise to meet that challenge will thrive, and those that don't will get passed by. And I hope both this amazing institution and the one I'm a part of are in the former of those two camps, not the latter. And I look forward to questions and thoughts on this topic. And it's a subject of an article that I'm working on with a JD student that we started over the summer that's really trying to tackle accessibility as not just an area for innovation and new initiatives to kick the tires on, but also as a part of public law that we sometimes undervalue and understudy, looking at what we ought to see as a framework for access as part of that mandate of these institutions. In other words, not a luxury that we aim for when we can afford it, but something constituent of what it is to be a law school, at least in Canada. And I look forward to sharing that with you and getting comments and feedback in addition to what I hope we'll have a few minutes for now. And thank you very much for your patience and for hearing out that talk.